All right, everyone. I guess we can get started. It's 12 o'clock sharp. So we're going to talk about everyone's favorite topic. And of course, I am being facetious. It is not a fun topic to talk about because it's one of the worst things, I think, as a business owner, as an office manager, as an office administrator, that you have to deal with, which is to let someone go. Now, we have over 300 registrants for this webinar today. So there's a lot of people out there who are looking to terminate an employee, it sounds like. But it is not, as you all know, if you've heard me do other webinars, it's not my favorite topic because, um, I really truly believe that there is something to be said for for finding the right person, but maybe they're in the wrong job in your office, and that we should be giving people the opportunities to potentially change positions inside an office because, again, they might be the right person, but just they're in the wrong job, and hence they're not doing their tasks as well as you would hope. But sometimes that's not the case. Sometimes that's not the case. And what that means is that we have to let that person go. So, how do we do it? How do we do it strategically? How do we do it intelligently? How do we do it while minimizing our risks of getting in trouble? And so that's what today's webinar is all about. We're going to go into some depth about the mistakes that we see on this topic because it happens all the time. And if I were to say to you that I am on the phone multiple times a day talking to either an existing HR for Health customer or a soon-to-be HR for Health customer on this topic, I would be not exaggerating because it is, multiple calls every single day on this topic because of the fact that it is such a hot topic and unfortunately, and such a risky topic. So for those of you who don't know me, my name is Ali Oromchian. I'm a dental and medical attorney, also the CEO of HR for Health. My goal in life is to educate all doctors around the country on all topics having to do with HR, their teams, practice transitions and other similar things so that we can minimize the risks to you while you're an operator, while you're an entrepreneur, so you can focus again on the business that you're running because it is what you were intended to do, and that's what you set out to do as an entrepreneur. And so we want you to focus on that while being able to minimize your risks today on the HR front. So what we're going to talk about, we're going to talk about the types of separation that are out there because COVID brought up some new terms that we hadn't thought of before and people weren't really talking about, but it's in our lexicon now. So we're going to talk a little bit about what those are. We're going to talk about, and we're going to spend a lot of time on separation mistakes because this is the bulk of where the errors happen. And this isn't stuff that you're going to read in a book. I mean, this is things that we see at HR for Health and at our law firm cause the most problems for our doctors. And so you're going to get detailed information on issues that other people in your shoes have done. And some of you listening today might say, oh man, this is very similar to something I did wrong, or this is something similar to what I wanted to do, before I called you, Ali. And so we're going to talk about those because I want you to avoid all of these things. And then we're going to talk about some solutions and leave some time for questions at the end. So make sure that if you have a question, don't hesitate to just type it into the chat box here. And Taylor, who's helping me with the webinar today, will either try to answer them live, by replying to you directly, or she'll queue them up for me at the end, and I'll spend some time answering the questions for you guys. Okay, so what are the different types of separation that we have? There's really four major ones that we need to talk about, right? Four major ones. And so the first one is your straight up termination. Now, what does that mean? Well, it means just like it sounds. You are terminating someone's employment with your business. Okay, and this is a very important um, uh, uh, term, because when we talk about termination, it is the end of the relationship, right? It is the end of the relationship. No way around it. And so some people try to kind of soften it a little bit, and we'll talk about that in a second, by calling it a layoff or a furlough or things of that nature. But we'll talk about that in the next slide. But really, a termination is the end of the relationship, and sometimes that is voluntary, which means that the employee is resigning, and then sometimes it's involuntary, which is you're terminating them, which is really the point of this first slide. Now, a resignation is very similar to that, which is it's a termination of the relationship. However, it's done by the employee. So the employee is providing notice to you that they are resigning their position. Now, they can give you no notice. They can give you a day's notice. They can give you a week, 2 weeks. There's no set law that says they have to give you any kind of specific notice. But resignation is that the employee is resigning their position versus termination where you are terminating them. Okay. Now, there's two other vocabulary words here that we need to know about. One is called a layoff. Now a layoff is very similar to a termination, because you're terminating an employee's employment with your business. Now, some people try to say, well, if I call it a layoff, it just sounds better than a termination. And maybe it does, maybe it doesn't, but it's the same effect. You are terminating the employee. Now, typically a layoff is considered to be done to like a group of employees. And so you might be laying off an entire division of, let's say, a company, if you own a massive company, or you're laying off a subset of that group because business is slow or whatnot. And you hear this a lot in the news, right? You hear about this tech company is laying off 10,000 people, or this other company is laying off a third of its workforce. What their point is that they're laying off an entire division or entire groups of people. So in your office, if you're laying off, let's say, multiple people because business is slow or something has happened, then you could potentially call the layoff, especially if it's for business reasons. But if you're using it kind of interchangeably with termination, just to soften the language a little bit, that's fine if you choose to do that. But just remember, the legal effect of a layoff versus a termination is exactly the same, right? So nothing changes as far as that is concerned. So that's very important for you to know. Now, a furlough is something we heard a lot during COVID, and what a furlough means is that it's a temporary reduction in the workforce because of some major event that occurred. Now, of course, with COVID, that was the major event. A lot of people got furloughed because we weren't sure when the offices would open again, and so people were furloughed. They weren't terminated. They were furloughed, which means that they were temporarily, their employment was more or less temporarily put on pause. Now, in many states, if you are furloughed for an extensive period of time, that is considered a termination. And so those rules kind of got ignored during COVID because everybody was being furloughed and the states didn't know what to do. But the rule, typically in various states is it could be as short as 3 days, it could be 5 days, it could be a little bit more. Where if you're furloughed for more than that period of time, then you're considered to be terminated. So these are the four categories. Now, a furlough, as I mentioned, could turn into a termination if it lasts too long. So again, it's termination. So at the end, what you have to remember is that regardless of what you call it, whether you call it a termination, a layoff, a furlough, any of and all of these things could be deemed just a straight termination under the right circumstances. Now, the thing that comes of this, why terminations end up being risky, is because of this claim that a lot of lawyers make on behalf of their clients, which is that they were wrongfully terminated, right? They were wrongfully terminated. Now, many of you here today will say, and we'll talk about this a little bit later, but you'll say, oh, well, I'm in an at-will state. I thought I could terminate anyone at any time. And we'll go into that in more detail. But a wrongful termination means that you terminated the employee for a wrongful reason, which will be one of the ones that we are going to talk about now. So it could be first that they were fired because they were part of a protected class, right? So what are protected classes? Well, there's a lot of protected classes out there, but the obvious ones are age, race, gender identity, disability, so that could be, a workers' comp or otherwise, pregnancy, socioeconomic status, things such as, whether they're, renting or owning a home, religious reasons. All of these are protected classes under the law, and there's many more, by the way, but these are the ones that are most commonly we see that are protected classes, that if you fire somebody because they are part of a protected class, then you could be in trouble. So if you say to someone, hey, congratulations on your pregnancy, but I have to fire you now, that would be a problem, of course. If someone turns 60 years old and now you terminate them, that could potentially be a problem. Along with a lot of other things. What we see a lot is, even if the employee is not the best employee, but you are planning on terminating them anyways, but then suddenly you find out that their gender identity is not the same as the one that they were born with, or that maybe they have gotten pregnant or thinking about pregnancy or something, and then you terminate them. It starts to seem like you're letting them go because of that. So that's the first reason we see a lot of problems. The second reason is if they report something that may be unsafe in the working area, and then you retaliate by terminating them because they're a troublemaker, right? So like, for example, if they complained about, and we saw this a lot during COVID, of course, but where maybe the air filtration system wasn't the best, or maybe the doctor didn't buy air filtration systems because they were hard to come by or too expensive or whatnot, and employees started complaining, and then they were let go soon thereafter. That could be a problem because that is them complaining about that. Now, same thing can apply about a lot of other things. If you have an employee who doesn't want to take x-rays because they're trying to get pregnant, for example, that could potentially be this. If there's issues with sterilization or other things in the office that may be deemed unsafe, that could be it as well. Okay, so you got to keep that in mind. Retaliation for reporting some illegal activities. So the most common thing here that we see is employees who may complain to the office manager or the doctor about about the office not, or waiving co-pays, for example, on insurance. That's like one very common thing. There's a number of other things. If there's like retaliation, or somebody feels like they're in a hostile work environment, right? They're being picked on, or they're not being talked to nicely and things of that nature, then that could, and they complain about it, and then they get fired. That could be wrongful termination. So keep that in mind. The next one is a very common one, which is not really knowing the medical and family leave laws around the country. And so in your, if you don't know the rules in your state and you fire somebody because they are on leave because they're taking care of a grandparent or a parent or a child or whatnot, that could be retaliation and wrongful termination as well. So just be careful about that. If you ever have an employee who's taking time off because of any of these reasons, it's always a good idea to call HR for help and start asking questions about what your rights are as a as a employer, and what do you have to provide in your state. Okay, if you're less than 15 employees, there's a lot more protections for you nationally. Some of the federal laws don't apply to you, although state laws can still apply. The next thing is jury duty. If you terminate somebody because they're on a jury, that could be a problem. In my 20 years and thousands and thousands and thousands of clients, I've never seen one of our doctors fire an employee for being on jury duty. And we've had some employees who've gone on lengthy jury duties because of, crazy trials and whatnot. But typically, as annoying as that is, and as much of an impact as that can make in your office, don't fire somebody for that. Again, like I said, I've never seen it, but it could happen. Reporting sexual harassment in the office. Now, a lot of times when we think about sexual harassment, we think about it as, kind of a senior doctor and a junior employee, your sort of traditional, relationship there. And it doesn't matter, male, female, being the senior doctor and male, female being the junior doctor. It could be, anything really in that sense. But which I mean could happen, of course, but I see more often sexual harassment and happening between patients and the employees, where the patients are making the employees feel uncomfortable, and then the employee complains about it or whatnot, and then gets let go. Or it might be with vendors, right? Vendors that come to your office. If they're coming in and they're, sexually harassing the employees and making comments and lewd gestures and all those kind of things, that could be a problem. And of course, anytime it's between employees and between employees themselves, that could be a problem, even if it's not a manager, non-manager kind of scenario. So just be careful of sexual harassment. If it becomes an issue, make sure you investigate and nip it in the bud and admonish whoever is doing these things. And if the violator is doing this repeatedly or even once, you could potentially terminate them. But be careful about terminating the person who was the victim in that scenario, because it could cause a lot of problems. Terminating somebody because they refuse to do an illegal act. So we've seen this a lot in dental practices, where a doctor will want an RDA, for example, to pack cord or do something that's not within the purview of their skills that the dental board provides that they can do. And then when the employee says no, I can't do that, then they get terminated. Things like that are of course unlawful. So please be careful about that. And waiving co-pays with insurance folks and others. Just be very, very careful. If you're going to ask someone to do something that's not legal or is unsafe, and if they refuse and then you let them go, it's gonna be unlawful termination. Finally, pregnancy discrimination, probably the most common problem we see. Someone says I'm pregnant, and then soon thereafter they're terminated. That could be a problem. Does this mean that you can never fire a pregnant person? No, of course not. If you have good documentation, if you show that that the employee has done some grave mistakes, they've tried to, you've tried to, make it better with them, you've had conversations, but it hasn't changed, that could lead and be okay for you to terminate them. But if you haven't gone through those steps and suddenly someone says they're pregnant and then you let them go, that of course could be a problem, right? Could be a huge problem. All right, so let's shift gears a little bit about separation mistakes. What are the 7, 8 things that we see frequently happen during terminations that cause you to get into trouble? All right, so the first one is believing that the probationary period, which is usually the first 90 days, is some sort of protective veil against you, or for you, I should say, against these kinds of claims. And it's really not. The 90-day probationary period, and it could be a little bit longer, it could be a little bit less. The probationary period is just an evaluative tool created by HR people to help you evaluate the employees. It does not change the laws at all with regard to HR compliance. And so you have to be very, very careful during the first 90 days. Now, our recommendation to protect yourself is very easy, right? First is you want to at the 30-day mark, after someone starts, do a review with them, sit down and say, oh yeah, these things are going well, these things are not going so well, and document it all, right? Document it all. Then at the 60-day mark, you can go back and look at the 30-day reviews and say, okay, here are the things that went well, here are the things that didn't go so well. Let's keep improving and working on it. And then you're documenting what's happened. Then at the 90-day mark, you do the same thing again. So a third time in the first 90 days, you sit down and say, okay, these are the things that worked well, but these are the ones that haven't worked so well. And then you can make a decision about whether or not to keep that employee long term. Sometimes you do these things and it's great, and the employee is fantastic, and they keep improving. No one's perfect, of course, but during those 90 days, they keep improving. And you're like, yeah, this is somebody I want to keep. And sometimes it's not. I mean, I talked to a doctor just this morning. They have an employee who's on their 35th day, and she's talking back to the doctor, throwing stuff to the staff, being poor communicator with patients and others. I mean, just a terrible, terrible situation. And when they tried to sit down with her and meet with her, she refused, right? She refused. And so those kind of things, are clear signs of you having good documentation of, hey, this person's not going to be someone that can stay here long term, because I've tried at the 30, 60, 90-day mark to try to improve them and they haven't. And then I'd have to let them go. And in that situation, so be it. But at least you have documentation. At least you have documentation. So please make sure you have that. And the reason is if you don't do these 30, 60, 90 days, and then the employee, let's say, gets pregnant in the middle of that, or gets hurt or whatnot, and then you do have to let them go, guess what? It's going to seem like you're letting them go because of the pregnancy, as opposed to real documented reasons. Okay, so again, first 90 days, it's really great to do a 30, 60, 90-day review. All right. The second mistake we see is not complying with final paycheck laws. Now, every state is a little bit different, in terms of timing. Some states, require you to pay the person the same day that you're terminating them, or you may have a few days if they have resigned. Some states allow you even more time. They allow you to wait until the next pay period to run the final paycheck. But whatever the state's rules are, you got to abide by them, to a T. And usually that means you have to give them their final paycheck, which includes all vacation time that they may have accrued. Remember, vacation time is considered accrued compensation. So by not paying them their vacation, it's almost like you're stealing from them. So again, really, really important that this get done. So make sure you're following these rules. If you ever have any questions, about these final pay laws, just call HR for help. They'll walk you through it and have you prepared before you actually go to terminate the employee. Okay. All right. The next thing is failure to document. Documentation is your friend. It is your get out of jail free card. It is the best way you can protect yourself, because if you're documenting things, then it's hard for someone to say, well, they just retaliated against me, or they're discriminating against me, or any of these crazy things that people say, because you've documented it, right? You've documented that they've been tardy, 23 times in the last 24 days, right? You document that, they're not ready to work when they're supposed to be ready to work, or they, use foul language with a patient or employee or the doctor owner, whatever it is, you want to document. Now, do I expect you to walk away from a patient and document every little thing? Of course not. That's not realistic. But it's important to take note of it and to document it at the end of the day. If you have an office manager or office administrator, have them do it for you. But really make sure you do it, because as time goes, our memories fade and we forget about all the stuff that happened. And then when you actually need the documentation, you don't have it ready. And then you have to do stuff like backdating or whatnot, which doesn't work. Okay. All right. The fourth mistake is relying on at will. We kind of talked about this earlier. At will is not really a thing. I call it the at will conspiracy, because 49 states are at will, which means that, you in theory can fire anybody for any reason at any time, or they can quit on you for any reason at any time. But the reality is, as an employer, it's really, really tough to let someone go. There's all these restrictions, all these reasons why you cannot let them go. And so, right, it's important to keep that in mind, right? It's important to keep that in mind because if you know that, okay, in a perfect world, I can let go of an employee if there's no issues, great. But for most of us, there are always issues, right? Someone's hurt or injured or pregnant or older or this or that. There's always some hair on the termination. And so we just have to be careful. And so my advice to you is don't rely on at will to just let somebody go. Make sure you think through it. Contact HR for help. Have some ideas about planning in terms of the termination, when you're going to do it, when the final paycheck is going to be ready, all these details before you actually do it. And so if you do that, you will minimize the chance of any serious problems. Okay. Converting resignations to terminations. So how does this happen? Well, the way this happens is that somebody gives you a resignation. They say, for example, all right, my last day will be, September, 30th. So they give you, let's say, 2 weeks notice. And then you turn around and you go, you know what? Because you're mad. You say, no, you know what? Tomorrow is going to be your last day. Just don't show up. Well, you took their resignation and you turned it into a termination now because you terminated them as of today, okay, or tomorrow. So don't, be very careful about turning resignations into terminations, because obviously resignations are better legally than terminations are for you. But if you don't want somebody there for the rest of their term, their 1 week, 2 weeks, then just pay them normally. Tell them they don't have to come into the office, but that you will continue paying them through their last day. And this is important to do if you think the person who just resigned is going to cause issues, right? If they're going to come in the office and cause issues with you, or with the other staff and things of that nature, then it's important to make sure you send them home and pay them, but they don't have to work. Okay. All right. Dismissing someone who's a part of a protected group. We kind of talked about this. Again, there's so many groups out there that are protected. If you guys want to download a white paper that we've written and some information we've written about the Pregnancy Workers Fairness Act, which is a new federal rules regarding pregnancy leave, please go ahead and scan this QR code, and then you'll be able to download it into your email address or into your email. So super simple. Just be careful. I mean, if it doesn't feel right, if your intuition is telling you, man, this could be risky because this person is in this category or that category, just pick up the phone and call HR for help. Let them counsel you through the termination, right? It's just as easy as that. Don't take a stab at it. Now, it doesn't mean that just because they're part of a certain race or nationality or because of their age or something else that they're automatically protected forever and ever and ever. It just means that you have to be a little bit more strategic in how you do it. Okay. All right. Number 7, over communicating is over talking when you are letting someone go. And so it's easy to try to fill the void of silence. It's easy to try to over talk because it's an uncomfortable scenario letting someone go. No one's happy about it. Everyone's nervous. It's a stressful time for everybody. Someone's losing their job, and you are the one doing that. And so there's a tendency to just over communicate. And so what I find is that over communication happens when someone is not prepared, right? They're not prepared. If you're prepared for the termination, then over communication shouldn't happen, right? Should not happen. Because the reality is that it's you know what you want to say, you know when you're going to say it, how you're going to say it, and so it ends up working itself out in that scenario. So just be prepared, and you should be good to go. All right. The final thing is unemployment claims. If someone does file unemployment against you, we recommend not to fight unemployment. Let them get the unemployment. It's a soft cost to you, which means that there's very, very little expense to you because you've already paid into unemployment, so you're never getting that money back anyways. And this is used to pay them. The formulas for unemployment are super, super complex. It has to do with your account. It has to do with the general account of all employers in California with the way they figure out the rates. But we see statistically that the rate of a lawsuit goes up exponentially uh, when you, as the employer, win unemployment. So my recommendation is just don't fight it, right? Just don't fight unemployment and let the employee get it for all these reasons, and it reduces your risk. Okay. All right. So what are the steps? What are the solutions for avoiding this? Well, as you can probably imagine, all the things we talked about are solutions within themselves, right? Are solutions within themselves because of the things that we talked about, right? Having good documentation, making sure you're prepared for the conversation, making sure the final paycheck is correct. All these things are must-haves. They're not nice-to-haves when we're talking about legal compliance. And so when it comes to terminations, they're always risky. There's almost no termination that's not risky unless you're terminating your I don't know, your kids or something. Even then there's some risk. But risks, there are always risks. So how do you minimize it? Well, you do the things we talked about. You create a process for the documentation, which then kind of takes out the guesswork from it. Your state's final pay laws that we talked about. You have the final paperwork, that you need in HR for health for it. You have them, they've already signed the employment handbook, so there's protections there. So you need to do these and many other things to ensure that you're compliant from a documentation perspective. So in sum, right, what we're really talking about is taking a very complex concept and really breaking it down into three things. One is identifying, right, identifying that it's risky, right, identifying the situation and identifying that it's risky because we know that it is. Then two is once we've identified that it's risky and that we still need to do it, two, taking the steps and avoiding the common mistakes that we talked about today that are the most common mistakes that we see, right? The most common mistakes that we see. And that is a vital part of this because they're so frequent. And then the third part is making sure that you have the documentation, which is part of the risk minimization that we've been talking about on the HR side. And so if you can get all that through HR for Health because it's all electronic and you've got your manuals, you've got your termination documents, you've got everything you need to make sure that if you have to terminate somebody, you can do it safely. Then you've got all three pieces and you've now made a very complex concept very, very easy with our help. Okay. So again, follow these steps. Terminations are always risky. Make sure you pick up the phone anytime you want to terminate somebody. Call our HR support and let them coach you through it. If you guys scan this QR code, you can book a demo with our team. They'll also send you a copy of our slides today so that you can have them and refer to them. I know some of you, are during your lunch break or you're driving, so you may not be able to. But they'll give you both of those, and then you should be good to go. Okay? All right. So, Taylor, any questions for me?
We do.
Uh,
Um, let's see. Chastity Moore asked, in Texas, the more unemployment claims you pay out, your unemployment tax goes up. Is this not correct?
yes, great question. It is correct. And it's not just in Texas, it's in all states. But the reason why I say don't worry about it is because of a couple things. One is every employee has a maximum unemployment amount that you pay towards them. So if you have full-time employees, then you pay up to that maximum and you don't pay anything more. So if you're paying a higher percentage, what it basically means is that you're paying faster into hitting that maximum, but you'll hit that maximum regardless because they're working for you full time. So that's the first reason. The second reason, and this is probably the more important reason, is that the calculation of your rate that you pay into unemployment is a very complex formula that takes into account your the claims against your account, but also the claims against all accounts in your state. So if, let's say, you have nothing filed against you, but the state unemployment is super low, meaning there's a lot of people filing claims against their employers, your rate will go up too, right? Because it's one massive fund that unemployment has. And so they make sure that it's divided across all employers. So you may have no claims and your rate might still go up, and you may have claims and your rate might go down. And so it all depends on kind of what's happening at a macro level in your state. And so that's why we say just don't, just ignore it, avoid it. The risk for the employee getting mad that you're preventing them from getting money from the state when it's not really coming out of your pockets directly is sometimes enough to go down the road of a lawsuit. So I always say just ignore it.
Awesome. Thank you. The next one we have, I like this question. Becky Smith wants to know if I think the employees have to sign the documentation.
Yes, great question. Yeah, you absolutely want the employees to sign it. They review it and they sign it. There's a whole bunch of documentations, Becky, that we have that are in our employment manual, and they're standalone documents. And we want the standalone documents signed too, because sometimes the employees will say, well, I didn't know that what this meant. And so there's some things that are so important that we make them sign a separate document as well. But yes, you want them to all be reviewed and all signed. And then if you are on HR for Health, obviously all of this is documented. It's all electronically signed. So, you should be good to go.
Okay. And we'll do one more question. The rest we will follow up with you individually from our team. And this last one asked, we are a small practice with 3 employees. Do you provide support service for a practice like ours? And I want to add to that and ask you as well, why would it be important for someone that has 3 employees to still invest in compliance and HR and an HR software? Why does that still matter, even if it sounds like it's a small amount of employees?
Yeah, no, good question. And Taylor, if you want, I'm happy to stay on if we want to go through some more questions too.
Okay.
So whether you're 3, 4, 5 office, employee office, it's important. It's even more important, I think, for you to get off the ground well with a strong foundation, because you will grow, right? The average dental medical practice around the country has anywhere from 7 to 12 employees, right? So you're not going to stay at 2 or 3 employees most likely, and that will change. And so when you have a strong foundation, when you have 1 employee, 2 employees, then it's easy to just add future employees on there and keep the policies the same. Whereas when you have more employees, it becomes much more problematic to suddenly change things. So like everything else, I think having a good foundation is good, is strong, and smart, and then you grow from there. HR for Health has discounts for young practices or new practices that have smaller employees. So our team can talk to you about that, because we want to make sure we grow with you. But yeah, I think starting strong when you're smaller is better than waiting. So.
Okay. And another one from Deb asked, question about vacation. Is vacation always considered accrued? In our office, we give new employees 40 prorated to use for vacation the first year and 80 hours the beginning of the second year. I always assumed if they left before the year was up, we could just hold the vacation.
Yeah, great question. So it depends on like exactly how the language is worded in terms of vacation. You can provide vacation in any number of ways. You can have it accrued. If they work a certain number of hours, they get a certain number of vacation. You can give it to them lump sum. You could give it to them after their year of service. So some employers say you have to work 1 year and then you get 3 days. If you work 2 years, like 2 full years, then you get 5 days. So it can be worded however you want. That's the nice thing about vacation, because it's not vacation, unlike paid sick leave, is not a required benefit that employers have to provide. So you can do it however you see fit. That all being said, right? That all being said, you have to make sure it's worded perfectly, so that if you don't want to pay it out if someone leaves, that it's worded like that. Because if it's earned, then you can't take it away, right? If it's earned, it cannot be taken away, and so that's really important to think about.
And we've got some juicy ones if you still have some time.
Let's do it. Yeah.
Okay, so Mimi asked, what if they refuse to sign? I love this question.
Kill them. No. No. If they refuse to sign, it depends on what they're refusing to sign. If they're refusing to sign new hire paperwork, then what I would do is I would ask them why. Ask them what they're having an issue with. It might be just an education issue, right? So they're not sure what they're signing, or they may have a question, so now they're refusing to sign. So then you spend the time to educate them on your policies, right? They might be like, look, I don't understand the vacation policy, and so I'm not going to sign anything. Like, no, well, let's sit down and ask, and then do what I do in depositions. Like, well, was that it? Do you have any more questions? Yeah, I have one more question. Okay, great. So don't be scared about answering their questions, right? Remember, you're not hiding the ball, right? Most of our doctors, I can't say all, but most of our doctors are not trying to hide the ball with their policies. They just didn't know how to do it well. And so now you have a tool that says, let me provide you with what our policies are, good or bad. Here's our policies. And so if somebody has questions about it, don't be shy about it. Talk to them through it. And then once they understand it, they should sign. Now, if they still refuse, then maybe they're not the right team member for your office. If they refuse to sign termination documents, then that's a whole different thing that we can talk about. If they refuse to sign the performance reviews, you can write down that they refuse to sign, and then have the employee at least initial that they're refusing to sign, and that can be just as good as having them sign.
Okay. And this one, sad to hear, employees tend to resign by text. I ask them to send a formal letter, but they don't. Is that okay?
Yeah, I mean, I hear you. It's text is replacing a lot of things. Yeah, it's not ideal, but it is sufficient for our purposes. It is a writing. What I would recommend is that you take a screenshot of the text message. Don't forward the text message or do anything else. Screenshot it into a picture and then save it, because when you screenshot it, it can't be deleted or lost, and then you put it in their file, and that can be good enough. So.
Good to know. And Jessica asked, in California, does the meal have to be before the 5th hour, regardless of the amount of employees in the practice?
The meal actually has to be before the 6th hour, regardless of the number of employees. So,
okay.
Yeah, so all employees get it before the beginning of the 6th hour.
Okay.
Yeah, these are great questions. Yeah.
I know, right? Do we have to give sick leave and vacations paid for part-time employees?
Ooh, good question. So it depends on your state. Sick leave, maybe. Vacation, no. Right? Vacation, no. Remember, vacation is not a requirement in any state that I know of. But sick leave is and can be, right? So if you're in a state that requires sick leave, then you need to provide sick leave to all employees. In most states, that's the case. Full-time, part-time, whatnot. But vacation, no. Now, if you change to PTO, paid time off, then that's a different story. You do have to provide that to everyone.
Okay. And protected class question, what is the proper solution for a pregnant employee that can no longer fulfill their normal job description duties due to their pregnancy? What can we do and not do?
Yeah, great question. So this is kind of a little bit of a loaded question because there's two different things going on there. If an employee cannot perform their task because of their disability, whatever that disability is, injury, pregnancy, whatever, they literally cannot do their job, then you can ask them to stay home, basically. I would never fire them, of course, but you can ask them to stay home. They don't come to work. But most likely, they're going to give you a doctor's note for some accommodation, right? So, for example, hey, I'm pregnant. I can't sit for more than, a half an hour at a time. Then, if the person is, let's say, a front desk employee, then you have to accommodate for them to get up every half an hour, right? Or maybe I can't work 32 hours anymore. I can only work 24 hours or whatever it might be. Then you have to accommodate for that. So you just have to accommodate accordingly.
Okay. Can you clarify?
Yeah, these are great questions. So, yeah, if there's anything else that we haven't answered, we will follow up with you guys. And we have your questions, so we will follow up. I know some of the questions are very detailed about very kind of very unique kind of scenarios, and so we may need a little bit more information before we can answer it. So, does that work, Taylor?
Yeah, that works. And for those of you that did answer a question and we got to you in here, we will still follow up with you individually and make sure that you have everything you need for the situation that you're in, and we can answer any of your questions as well, and if our software can help you with them. But that was so much fun. Thank you, Ali, for taking the time to do that with
My
us
pleasure.
today.
My pleasure. Thanks for everyone for being on. All right, have a great rest of the week.
Awesome. Bye. Thank you, everyone.
Bye.